beg your pardon, Mr. Chair, just getting set up here.
I understand you got Mr. Terrell with his big knees blocking you behind you, I see. Thank you. If you would introduce yourself officially to us, along with your, so you have some staff with you.
Yes, sir. Mr. Chair, members of the committee, my name is Jason Williams. I'm the district attorney for the Parish of Orleans. I'm joined by team member Tim Browning and team member Micah Entz. Let me just say, as we start off, I think it's really clear that we are here because of certain misunderstandings, I thought. But after listening to the last presentation, I think that's better put. We are here after a misleading. Pronouns were used. They did this. They filed this. They were released. And we're officers of the court. We're lawyers. And we can't dabble in gray areas of they doing anything. Everyone has a role in a court of law. Defense attorneys file briefs, judges conduct hearings, and the district attorney is on the other side of that V. The district attorney's office has been delivering justice and accountability in the city of New Orleans, and we are seeing the fruits of that labor. Public buy-in in the justice system in New Orleans is up, and violent crime is down. I know that Ms. Canizero would love to suggest that crime just went down, but crime started going down at the beginning of 2023, and it was no accident. I'm very proud of the work that this office has done on every floor, in every section of court, of the courthouse. And I'm very proud of the smart public safety partnerships that we built in my 3 years of being DA. Nationally, our federal partnerships are stronger than ever, specifically with the Department of Justice, U.S. Attorney Dwayne Evans, the ATF, the FBI, and the United States Marshal Service. This time last week, I was personally cross-examining a murder defendant, Preston Higgs, in Section E of Criminal District Court. We tried and convicted a brutal axe murderer who led us and the U.S. Marshal Service on a 4-month-long fugitive manhunt across multiple states, Minnesota, Illinois, Iowa, Alabama, and Tennessee. Big thank you to Marshal Brian Fair for his efforts working with us to track this person down, collecting evidence every step of the way so that we could hold him accountable, and he'll be spending the rest of his life in jail for the murder of a beloved teacher, Elizabeth Quackenbush.
Thank you for that.
I was with the ATF. Thank you, Mr. Chair. I was with Alcohol, Tobacco, and Firearms Special Agent in Charge Joshua Jackson on yesterday. We have been working strategically and surgically to go after drug peddlers and illegal gun dealers in New Orleans. That partnership has assisted us in doing something that prosecutors, mayors, and parish presidents have struggled to do historically in the state, which is shut down problematic businesses that are fostering and breeding criminal activity. Our partnerships on the state level, we have engaged in the most robust partnership that has ever existed between the governor, the attorney general, the state police, and any parish in this state. We did not let party affiliations or national politics get in the way of public safety at home. We are communicating on a regular basis and meeting and focusing on decades-old problems for the benefit of Orleans Parish and for the benefit of the state of Louisiana. And we've created a model that could be replicated in other parts of the state with Troop NOLA. To your point, Senator Miguez, I know the rest of the parish doesn't want to work on and spend money on fixing New Orleans' problems, but I think we all realize that New Orleans generates a lot of money for the state. And if New Orleans is healthy, the state is healthy. And I know that Troop NOLA and spending that amount of money can't last forever, but it can create a model that can go up and help Washington Parish and Bogalusa and other hot spots so we can get things under control. Locally, the partnerships have never been stronger. The City Council and the NOPD, these relationships are tighter than ever. I came from the city council, and Chief Kirkpatrick has been an amazing partner. My office right now has former NOPD Police Chief Michael Harrison and NOPD Police Chief Michelle Woodfork on our team, giving my office more firepower from law enforcement than it's ever had before. Michelle Woodfork was a partner to me in bringing down violent crime in the city of New Orleans faster than any other city in this country and any other parish in the state after the surge in violent crime after the global pandemic. Her work internally, working with former CIA, FBI, and NSA agents to build stronger cases against the most violent offenders, is earning national attention. These federal, state, and local partnerships are unprecedented in the state and in this country. Innovative collaborations with business and local nonprofits like the NOLA Coalition and No Dice are working to reduce crime and prevent new victims from being created. All in all, what I'm saying to you, Mr. Chair, I'm going to jump right into the heart of the matter in a second. I work to pursue public safety and public buy-in through addressing past harms is absolutely working, and we have the public safety numbers to prove it. And I want to welcome you, Senator, to come to New Orleans, not just read the files, and you, Senator Cloud, and you, Senator Klein-Peter, and you, Senator Miguez, and Mr. Senator Plessis, you know the city, and Senator Abrams, I want you to come, and I'd like for you to sit in during jury selection in the next murder trial that I personally try, so you can hear from our potential jurors when they say they cannot sit in judgment because of the number of times that the Orleans Parish District Attorney's Office has gotten it wrong. They don't believe they can convict because of the errors that have been made in the past in my city. I created this Civil Rights Division because my jurisdiction is an outlier in past defective convictions. And that has sunk public trust in our system, which has made it harder to prosecute violent crime and historically made us less safe than other parishes. We can only have public safety in New Orleans when people believe that the justice system is working for everybody in every neighborhood.
Okay, since we're approaching the lunch hour, I feel like we need to get in the middle to the heart of this.
Give me 30 seconds to jump into it. I promise I'll get to it.
Okay, because I've got some questions, and I know the committee's going to have questions.
Promise I get to it.
Sure.
What I just described, that trust is present in your districts. Senator Morris, your prosecutors all have the trust of their people and their jury pools. In New Orleans, we have a harder relationship with this. Predecessors in my office have contributed to that, including some of those who were just at the table slamming my efforts. New Orleans has been known for injustice for quite some time, and I'm just really trying to clean up that reputation as it relates to constitutionality and equal justice under the law. We have won some very difficult cases in the past 3 years, not because we have some massive police force now or some huge roster of prosecutors. No, it was because my lawyers can go anywhere, any high-rise, high-rent high-rise, or low-rent motel, and people are going to trust my ADAs, and they're going to cooperate because they know we care about getting the actual bad guy, not just someone who looked a little bit like him. Witnesses are coming forward to help us prove cases. People are actually proud to be a part of public safety in communities where they were not before, and we have the biggest drop in public safety to show for it. We had the highest rate of imprisonment in the world. We had the highest per capita wrongful conviction rate in the world. We had the highest rate of people serving life and parole in the world, and the highest exoneration rate, meaning an innocent person was sitting in jail when the convicted person was left out in community. And when we had those times, we also had the highest rates of violent crime. So New Orleans has proven that over the past several decades that more people in jail does not make a safer city. And I just hope that I get as much time as Ms. Canizaro had.
You will, except that we've run so long that I don't want to end the meeting prematurely because there are a lot of people that want to say some things. So, thus far your testimony is appreciated, and I understand your position. on what you allege are past wrongs. Nonetheless, we're here to talk about post-conviction relief and what has happened in the last couple of years. So I'm going to jump into some questions. You have a staff of how many in your office? 150 or so?
A little more than that.
Between 150 and 200?
Yes.
And how many attorneys do you have?
We've got
Roughly.
2 per all 12 sections of court, 6 in juvenile, 3 in civil rights. I'll tell you, we don't have enough.
I see. And you have a division for felonies, a division for post-conviction relief, or a division for, how is it divided?
So when we found ourselves with spiking violent crime and the murder rate was going up, I went to the city council and I asked them to help us fund a homicide unit where we recruited and brought in the most talented folks we could find to build out a homicide unit with folks who could try those cases, and we've had huge success with that. We built a SACA unit, which deals with special victims or sex crimes units. It deals with crimes against children and other sexual assaults. We have the appellate division. We have the civil rights division.
What about post-conviction relief? How is that handled?
Post-conviction reliefs are handled in the appellate division as well as the civil rights division.
Okay, those two areas handle that. And do you have policies and procedures relating to post-conviction relief of any sort, including motions to resentence, et cetera?
We handle cases on a case-by-case basis, and we make sure that everything is handled in open. The policy is that things are handled on a case-by-case basis, and that matters are handled in open court as it relates to any post-conviction.
Do you have any criteria or written memoranda, internal written policies on how your staff is to handle requests for post-conviction relief?
Yes, Senator, we have policies that make it very clear.
They're written policies.
Yes, and we'll share those with you.
Okay, and you'll provide those?
No problem.
Okay. Are they policy manuals or just memorandum?
Correct.
Okay. You have both? And who enforces those policies?
I do.
Do you review each and every request for post-conviction relief in a situation where your office agrees with the request for relief? In other words, where you go in and concede, do you look at each one of those?
I do, but I think I need longer than a yes or no on that particular question, because oftentimes, and this was absolutely molested and maligned by the last presenter, there are a number of post-conviction relief applications in which we assert procedural bars on a regular basis. There are a number of post-conviction matters which we fight to the hilt. And we sometimes lose those matters, meaning a judge has granted a new trial. And when a judge grants a motion for a new trial or grants post-conviction relief, that can put a DA's office in a very tricky position in terms of not being able to put together the witnesses necessary for a 20-year-old case. And in those situations, we have had to reach resolutions with the court. And when those resolutions are made, yes, Senator Morris, I am availed and aware of what is occurring. And I want to make it really clear, one of the biggest policy points is that there is robust victim and next of kin outreach in every single matter that is handled, whether it be on trials, whether it be on post-conviction.
Okay. So you look at all of them when they come through, and you contest some requests for post-conviction relief. How many hearings have you had where you oppose post-conviction relief this year? Have you had any whereby there was an actual contested hearing, evidence produced for a request for any request for post-conviction relief?
Let me answer that question a couple different ways. So, well, not a couple different ways, but on a couple different points. So, if you listen to the statements of Ms. Canizero Rodriguez. no,
aside
but
from
I've
that,
gotta-
I just want you to answer my question.
Give me the question again.
Have you had any contested cases this year in which there was a hearing over whether or not post-conviction relief should be granted, whereby you were defending the conviction, the defendant was asserting its entitlement to post-conviction relief, and there was a court hearing? Have you had any
Yes, Mr.
this
Chair.
year?
Yes, Mr. Chair.
And how many?
State versus Wilbert Johnson. Since April of 2024, there have been 38 summary objections to post-conviction relief, beginning with State versus Wilbert Johnson. There are also cases
You
that
filed objections, but there haven't been hearings on them yet.
still open. Cases are still
I got
open.
you.
We're still fighting them. And
Okay.
there have been others where there have been hearings, and there have been others that we have fought and won, and there have been others where new trials were granted, and we tried those cases. I think it's important to note the Will Smith case, the case involving former Saints Will Smith, who was murdered. That case was overturned and had to be retried. It's very difficult to put together, so I tried it myself, and we got a conviction. The case of Evangelista Ramos himself, the pinnacle case that has been discussed in this courtroom, in this committee hearing, was a case that went up to the United States Supreme Court. I believed, and my office believed, that Evangelista Ramos was still guilty of the crime. We did not believe that that case was deserving of relief. And we retried that case before Judge Pittman in Section F.
Yeah, but nobody's accusing you of letting every single criminal go.
I thought I heard her say it, Judge.
No. But we're concerned about the number, but be that as it may. How does your office go about determining whether or not you're going to agree to post-conviction relief?
So, let me see if I can explain it a different way. A lot of meat was left on the bone based on that last presentation. Once a post-conviction relief is filed with the court, the defense has an opportunity to present evidence. And
They file a motion,
yeah, they file a motion.
but they don't present evidence unless there's a hearing, right?
But when there is a hearing, and there were multiple
But I'm asking
hearings.
about where there's no hearing because you agreed, your office agreed to the relief.
So I can
So
give you-
how do you decide, how do you go about deciding whether or not you're going to agree to the relief?
So I'll give you one good example. Each case is different because there's no.
Right, but you don't have a process? Like, this is what I have my staff do. Do they write a summary of the case? Do they provide them to you? Do they provide them to Ms. Maul, your civil rights directors?
I think I
And
follow
do
what
they
you're saying.
analyze it? Do they go back and look at the transcript? Do they interview the attorney who allegedly didn't provide effective assistance?
All of the above. Everything you just described, Mr. Chair, is what is required in every single case. And what I'm talking about is.
So you go back and if there's an allegation of ineffective assistance to counsel, you go back and you contact the attorney?
We contact every single person we can find, and we go through every bit of evidence we can go through. And I can show you how we've documented that because we've kept very good records of that. And I know that you've got some requests for documents, and I absolutely want you to get those documents because I want you to see what was said by the court, what was pled by the defense, and what our actions were. And I'll give you one example, just to kind of describe the process to you. Case of Jermaine Hudson. Jermaine Hudson was convicted by a 9-unanimous jury of an armed robbery that happened in 1999. The victim said that he was robbed. He told his dad he was robbed on his way home from work. His dad called the police. Police came. He picked out Jermaine Hudson out of a lineup. Jermaine Hudson stood trial. Jermaine Hudson was convicted. As we were reviewing this post-conviction relief, Mr. Hudson, as we were reviewing this, after 22 years, the alleged victim called from a rehab center in Houma to tell us that he had lied, that he was never a victim of an armed robbery. He didn't want to explain to his dad that he bought some dope with the money, and he told his dad that. Jermaine Hudson was preparing to plead guilty to a lesser sentence to get home to meet his adult son, who he had not been in his life forever. And I found out in my first year that an individual was sitting in jail for a crime that had never even been committed. And let me say this, that was not because of prosecutorial misconduct. I know the prosecutor that tried that case. I know him very well, and he did his job very well. He was lied to. The police were lied to. And so I was in a position where I was about to have a man plead guilty to a crime that never even occurred. It required us to get into the records, and the records didn't show it. It was this victim, alleged victim, who came forward and said that the crime never occurred. And I just need to tell you this one part. He said he tried to call the Orleans Parish District Attorney's office before, and no one would listen. And when we asked him why he tried again this last time, he said he heard that there was a new DA that was actually looking at the old files, that was actually allowing hearings to be had and allowing judges to make a decision about whether or not somebody got a fair trial or not. Sorry it took so long, Senator.
Okay. Well, look, I'll just jump right in. I haven't had time to review a lot of these files because, quite honestly, we didn't get much information until very recently. But I just picked up one that I think maybe Ms. Rodriguez may have mentioned briefly, and this is the case of Matthew Miller. And so I looked through, and that we have the pleadings and whatnot, and the facts as recited by the Fourth Circuit on appeal says that on April 7th, 1989, 8:20, Lisa Miller, the victim's two young children, victim's roommate, Tammy Duplessis, I'm sure no relation, were in the upstairs apartment. Directly below them, watching television, were other friends. The defendant, Matthew Miller, had approached the apartment, began knocking and banging on the door. He continued until the door gave way and then entered the apartment. The defendant began beating on the victim, and Ms. Duplessis yelled to Ms. Cordova out of the open window to call the police. Ms. Cordova called the police twice, went to the upstairs apartment and found the defendant sitting on top of the victim in a straddle position, beating her. Ms. Cordova grabbed the defendant from behind and pulled him off the victim. The victim stood up, ran downstairs. The victim, once inside, locked the door. The defendant went to the kitchen, removed a knife, ran out of the apartment, knocking down Ms. Cordova, attempting to stop the defendant. He ran downstairs, located the victim on the floor of the back bedroom, and began stabbing her in the chest with the knife, resulting in her death. Now, in response to the post-conviction relief requested goes like this. Although they were, now this is the defendant's attorney saying this stuff. Although they were very much in love, Matthew and Lisa's relationship was not a healthy one, which that's ridiculous. They were in love. The day after they got married, Lisa kicked Matthew so hard they had to spend several days in the hospital because she had ruptured his testicle. Lisa's behavior could be unpredictable and aggressive. She often initiated fights. As Matthew's brother Charlie recalls, Matthew would come to my house and he and Lisa were fighting to avoid altercations. Lisa would start fights over little things. It was as if she was looking for something to argue about. Clearly, victim blaming right here in a domestic violence situation. So in response, your office says the state hereby affirmatively weighs all procedural defenses it may have to claim in the case. Your office concedes in their pleading that the victim they have expressed opposition to a reduction in the sentence on their own behalf and on behalf of their father, who is healthy but elderly. They are planning to attend future hearings in this matter. And in the face of this, their claim was ineffective assistant of counsel. And looking through your response, your office's response, I think it might be, let's see who signed the pleadings here. The only thing that is said in the response about the argument of ineffective assistance to counsel was that they claim there's ineffective assistance to counsel without going into any detail of why that was the case. This case raises arguably legitimate constitutional concerns about Mr. Miller's conviction and adequacy of legal representation provided him on direct appeal. The state agrees that there are potentially meritorious constitutional grounds for relief. You don't say what they are. You just say, we're just saying that it was ineffective assistance to counsel, and then you agree to the relief, and the order is stuck in front of the judge, and he signs it. Now, does this concern you at all, that the victim was against it, that you did not, despite what you say as having a very detailed investigation for each post-conviction relief, not one detail about why the relief was being granted other than ineffective assistance to counsel? I mean, I probably could have made up something. Do you have the concern that that person who brutally murdered his ex-wife being set free?
Yes, sir. Yes, sir. Look,
So why would you engage in this to let somebody like that be set free without any articulable justification for it?
Well, I don't agree with that.
Well, it's right here in black and white. I mean,
they're more. Tell me when I can go.
You didn't put any. If there's more to it, you didn't put it in any of your pleadings. Or in this particular case.
And Senator, we talked about Jermaine Hudson, which is a case of a person who was not just innocent of the crime. There was no crime. In some situations, when there's a hearing and evidence is presented, it shows that there was either cutting of corners, violation of constitutional rights, violation of due process rights, or cheating by the prosecutor. That can happen to an innocent person, and that can happen to a guilty person. In this particular case of Matthew Miller, defense filed a post-conviction application arguing not just ineffective assistance of counsel, but they also raised Brady claims for improperly withholding evidence. They raised NAPU claims, as well as that ineffective assistance claim.
What exculpatory evidence was there that was not provided?
Well, I don't believe. See, this is where it gets.
I mean, you just said Brady. I didn't see it in here, but it doesn't mention what exculpatory evidence was withheld.
Just let me answer.
Sure.
I said the defense filed Brady, NAPU, and ineffective assistance claims. That doesn't mean I agree with what the defense filed.
Your pleading says you agree with it.
The pleading says that we agree with the ineffective of assistance claim, not the Brady and the NAPU claim, which would have exposed my office to a lawsuit had that been granted. Had a motion for new trial and a post-conviction been granted based upon Brady and NAPU, now my office would be exposed. So by reaching a resolution where we maintain that conviction, we are not exposed. And yes, there was opposition to the resolution by the victim. And yes, we were in deep communication with them. And we read the victim impact statement from the family on the record to the judge in an effort to make the claim. I'm not suggesting Matthew Miller was an innocent man. I don't think he was an innocent man. And we were trying to protect the conviction in the face of losing it because of Brady and NAPU claims that had been filed. I'm not saying I believed in the Brady claims.
Okay. I feel like that's a stretch, but anyway, I need to go into some questions. I got Senator Cloud.
Thank you. And thank you, Mr. D.A. Williams, for being willing to be here today. And I want to, on a good note, thank you for working with the Attorney General, the administration, the state police, and all the things that you are doing to make New Orleans a safer place. I think the governor at one point said, as New Orleans goes, Louisiana goes. And so we all have a vested interest in your work. I want to say a few things and ask a couple of questions. I know we're short on time. I think the first thing I want to say, and if you just let me run through it all, and then we'll go back and address what needs to be. But
Yes, ma'am.
on your statistics for the highest exoneration, I guess I really would like to see the statistics. I want to know, when you were saying that, how that data is where it's coming from, what it's derived from, and the actual data itself, if that could be
Mike
provided.
Answer is making notes. I'll make sure we get that to the whole committee.
Okay, be provided to us. And then, on a personal note, I don't believe that everyone should be locked up. I think that people make mistakes, and some people make very bad mistakes. And I don't believe I'm not a lock everybody up kind of lady, but I do think that there has to be consequences for bad behavior, especially when it's multiple times of bad behavior. It's just, society demands it. And I certainly, after working for 5 years now in the criminal justice system and walking the halls with a lot of inmates and on death row with inmates, I would hate to know that today there sits an innocent person still. So just there's that. And then I do want to say I have a few DAs from my district. I have 5 district attorneys in my Senate district, and they're all very great men, and they do very great work. One sitting right behind you, and Charlie Riddle sitting a few rows back. And I have not ever heard or seen such cases. I haven't. No disrespect of people being let out after such egregious crimes. I haven't seen that in my district in the 5 years that I've worked with them. So this is all very new to me, and I want to understand why. I also have been learning a lot about the parole board and the process by which people do get parole. And I guess kind of pivoting off of what Senator Morris said, there is a mechanism and a really stringent review to make sure that those individuals, though they've committed some very egregious crimes, are ready for reentry into society. And we want to be, at the very least, if this is the process that we're going to, within our law, that we're going to put our stamp of approval behind as a legislature, we want to be confident in your process. We
Yes,
want to
ma'am.
be confident in the parole board's process. And we have to have that demonstrated. We deserve that to be demonstrated to us. And I think you would agree, if you were sitting in this seat, you would want the process and the sanctity and I guess a methodical nature of it, and serious scrutiny to be demonstrated and protected. So just speaking to what I do know about the parole board, and was supposed to go last week to watch one of their hearings, and I plan to go sit through it. But I know that they go through review of reintegration plans, resilience, work plans. They look at the support that they're going to have for family and community upon reentry. They speak with law enforcement, those that are in the facilities with the offender, like the warden and others that have had one-on-one, experience with them. They look at their behavior and whether they have many marks against them and how long ago those marks were on that individual. They look at whether they're taking accountability for their actions and whether remorse is being demonstrated. This is all kind of in a rubric, and they're checking boxes and really going through a cross-examination for hours, days, maybe months and years in some cases with these individuals. They look at risk assessment scores. They look at the age of the offender and the time served. And they look at participation in certain programs, because we know that there are certain programs that that offenders go through that help them kind of reset their thinking, and they weigh and measure their participation, their behavior again while they were incarcerated. So these are all things that they go through, they document, and it becomes part of the record on their decision. And so can you provide on these cases where we've seen some very egregious crimes committed and the release of those individuals, can you provide the documentation just like we expect of the parole board? These such things and maybe more, and to provide that to us. If you're truly going to counter and have people here at the table to counter with the documentation to prove that you've done a thorough review, and so maybe provide that to us.
Mike Hance, will you make sure that Senator Cloud and the rest of the committee have all that documentation? And it may not be in the brief itself because there's not really a place for what that reentry program or intervention would look like. But we have engaged in exactly what you've described, and we will share that information with you in terms of where they are now, where they went when they first came out, whether we fought it and lost it, or whether it's one that we resolved. So we will absolutely share that documentation with you because we have it.
Could you
Because we're, yeah, I'm not cutting you off. I'm not
Okay.
cutting you off. But since we're on this topic, just to kill two birds with one stone, so to speak, I'm going to introduce this letter into the record in which I've asked that you've already received, asking for documents. Mr. Browning alerted me that you wanted 90 days rather than by the end of this month that I had requested. And, 90 days is just too long, but I would like to get your agreement to provide the documents requested in this letter within 45 days to the middle of October. That's
A month may be enough time. There are certain requests that I think make it a little bit difficult, but 45 days, I mean, we're going to do our best to get you, everything is on the record. We're going to provide everything that
Very
we
hard.
have access to
Right.
to you. Just like we dropped off a bunch of binders to the AG.
Right.
We have nothing to hide. We want you to see what we, like my son, when he's doing math homework, teacher wants to see how you got to the answer, and I want to be able to provide that to you.
okay. Well, I'm going to, I think the record's clear. You have received this letter. I'm going to introduce this into the record. So I'm sorry to interrupt you, but since we were on the subject of documents, I thought I'd get that out of the way.
That's perfect. And I think I wanted to just make the point that, in saying what I'm saying, in comparing the process of the parole board, I do realize you don't have the same discretion and authority of the parole board. But I think my comments are more that you're taking time and a methodical nature to bring in all the stakeholders that have a rapport and history with the offender before you're making decisions. I mean, imagine being one of us, seeing all of those things and hearing all of those things. I'm not concerned with past administrations or the politics or any of those things. I'm concerned about what I saw.
And look, I saw Senator Morris when I was getting coffee this morning, and look, you all are good people who are trying to do the best for the state. And so the fact that you want to have a conversation about this very complicated thing that the AG did a really good job of showing how it works, I think it's a good thing that we're having this type of dialogue. And the fact that and I'm going to get you those statistics so you can see how we have been presented to the country. And I'm not talking about Louisiana, I'm talking about New Orleans, Louisiana. I'm going to share that with you. But there's work to be done, and if there's a better way to do it, I am open to it. In the words of John Lewis, we might not have all come over on the same boat, but we're on the same ship together right now. And I look forward to improving my city because I know that's going to improve the state.
Well, thank you. Thank you for being here.
Okay, thank you, Senator Cloud. Senator Klein-Peter is next in the queue.
Thank you, Mr. Chairman. Thank you, Mr. Williams, for coming today. It is important. New Orleans is important to this whole state. I have a couple questions specific to some of the things that were brought up. The one that admitted to the murder, does your office plan on
Yes, sir.
taking Mr.
Yes,
Green?
sir. It's just not as quick as some folks might want it to be. I want it to work. I want it to stick, and I want to make a good case. But we are actively working on that.
Okay. And then,
In connection, just since Senator Kleinpeter's on that, you didn't provide use and immunity to anybody in that case?
No, sir.
Okay.
No, sir. And we didn't bring him to court. That was the defense attorney who presented that witness to
Okay.
the judge. And
Okay.
the judge, as an officer of the court, heard it.
Okay, fair enough. Okay, thank you.
And-
I'm sorry.
I don't know if you have the statistics, or maybe we can get it on the next, but has crime really gone down, or has the prosecution gone down? There's an Instagram, I'm sure you're aware of, Bayou Mama Bears.
Yes, I
And there's
am.
one a post 2 days ago that I really am interested to hear your thoughts on this. Are you aware of DeAndre Hickman?
I was alerted to the post, but I was preparing for today. I'm not done any other work.
He was
on that.
arrested in 2023. DA refused charges in 10/10/23. He was arrested for strangling his girlfriend and stealing again in November of 23, and the DA refused charges in 12/1/2023. In May of 2024, arrested for beating up his girlfriend again, and the DA refused charges 6/18/2024. And here recently, on August 27th, arrested for armed robbery. That's my question is crime going down, or is the prosecution going down?
Crime's going down. By all measurable standards, except for sexual assaults and sexual violence against women, every single category that is measured nationally shows that the city of New Orleans has reduced crime in those categories more so than any other city per capita. And that's just data. That's not my numbers. I didn't come up with that. And with regards to that particular individual, I don't want to speak on an open case, but I will tell you that domestic violence cases are extremely, extremely difficult to prove. I will never blame a victim or a survivor of any crime. Oftentimes, folks are willing to call the police, but they're not as willing to come to court and testify, and there are a multitude of reasons why that occurs. I've seen domestic violence in my own family, dating back years ago when I was 8 years old. My aunt finally left the man that had been beating on her for years. And he went to go retrieve her in Bogalusa and said she better come home. And then when she didn't come out of that door, he shot my two uncles in front of her. So I know how difficult it is to get out of those bad situations. It's the hardest cases we have to prosecute. They keep me up at night. And we're coming up with strategies to use body-worn camera footage so that we can prove those cases so that the partner or the woman doesn't have to testify. But we can just use that body-worn camera footage to show the injuries so that we can get dangerous people off the street.
I have no further questions. Thank you, Mr. Williams.
Thank you, Senator Kleinpeter. Senator Miguez.
Thank you so much, Mr. Chairman. DA Williams, thank you so much for joining us here today. A question about, we talked about policy earlier. Do you have a written policy on chain of command for major decisions like resentencing, plea deals, charging decisions?
It's got to come through me.
Okay, and what does that policy look like down from you?
Down for me.
Like,
what I'm
as
saying.
in, how does that policy work for each one of your ADAs coming up to you? I know you.
Okay, I see what you're saying. So, for example, policy decision on the habitual offender law. When I came into office, we were not using the habitual offender law because, as you just heard from Senator Duplessis, my predecessor was using it almost in every single case, whether it was one joint or pill. And so we got the state paying for people who are addicts. That's not smart. That's not wise. It's a better use of money. And so we then reintroduce the habitual offender law for violent offenders, either someone who was violent before or is violent now, right? And so we reintroduced it, and my lawyers have to write a quick memorandum to me why they want to use it in this particular case. Why is this guy so bad? And every single time that it's been requested, it's been granted. But we are making a record of it. We've got an agreement with the Tulane Law Clinic where they check our the use of the material witness warrants because we were sued for that because of some decisions by the last administration because people did not want to come testify. We have only had to issue one material witness warrant in my 3 years, but that process also has to come through myself or the first assistant. And we have to make a resolution, whether it's a resolution that turns my stomach or it's a resolution that I think's the right thing because the person is factually innocent, that has to come through me as well.
And you're involved at the last buck in every decision, right?
It's all on me. That's why I'm here.
Is that a consistent policy across each division?
Well, I will say that with regards to the trials divisions,
How does in particular the civil rights division work?
comes through me.
Okay, comes through you, and that's consistent policy. What about your policy for the civil rights division on screening cases? How they choose which cases to review, and what are your general aspects on that policy?
So when we were in the middle of, and I'm sure you all remember, the flux sort of area when the Supreme Court was deciding the Ramos case and the Edwards case, it wasn't clear exactly how everything was going to fall. I want to be briefed on every case that is going to be dealt with, but there are filings that have been made. There are requests for records by defense counsel. That's step number one, right? Because they don't have those records. Step number two is some defense attorney files a post-conviction with the court. The way it works in Orleans Parish, some of the courts will say to the defense, I'm giving you X number of days to respond to this filing. Some courts don't even let us know that there's been a filing, and we don't know about those. I can't tell you how many of those exist. We then respond to that, and then hearings are had.
Earlier in some of the earlier testimony, there was some statistics given about the 350 resentencing cases since you've been elected, as well as 42 cases just this last year. And they made some comparisons to local jurisdictions like Jefferson Parish, St. Tammany. I think even East Baton Rouge Parish gave some statistics which were gave us the impression that subsequent post-conviction relief isn't used very often as compared to your office. Can you give me, maybe a quick general explanation of why it's used so much in Orleans Parish?
When you look, so I remember I was elected maybe, I'd been in office maybe less than a month. And I was meeting with the DA of East Baton Rouge. And I had a bunch of questions because I just got the job. And we sat down and he was walking me through his process, and I took some forms and we sat down with his team and we worked together to sort of orient me with this work. And one of the first questions I asked him, I said, how many times y'all use a multiple bill? He knew every defendant's name and he knew exactly how many it had been used. Whereas in Orleans Parish, when the person would come to court for arraignment, they would say his name, they would say his bill status, and they would say, we're going to bill him if he doesn't plead guilty. And so 2,700 compared to a handful means that we got a lot more people sitting in jail for chump amounts of dope or marijuana or low level, stealing an umbrella off a porch, stealing some hedge clippers, going to jail for double-digit years because habitual offender law was applied. So yes, we have intervened in some of those situations, and some of them, a lion's share of those don't involve any violence.
Your testimony would be the main reason would be your opinion, the excessive use of multiple bills in Orleans Parish compared to others.
We have been an outlier in terms of how many people we've been sending to prison and for what. It's very different compared to what other DAs have been doing.
So there's some other statistics, data that shows, and tell me if you disagree, that the 42 that were mentioned earlier, many of those happened over the summer in a very short term, right before the new bill took effect on August 1st. Is there an explanation why so many resentencing in such a short amount of time and an increase of the statistical data there?
Yeah, I saw the tweets and that were put out saying that we were speeding up to this date. Number one, I wouldn't have done that to my partner behind me, the AG. She's been an amazing partner to the city of New Orleans in terms of figuring out ways to augment the DA's office and getting Colonel Hodges where he needs to be to help us reduce crime. We have a data sheet that I can share with you all that shows down to quarter two, quarter one, quarter two, quarter three of all the cases that we have resolved. And when you look at the number between 2021, 2022, 2023, 2024, there were more of these sorts of cases in 2021 and 2022. There were less in 2023 and less in 2024. There was no rush to do anything. These things are filed by the defense attorney. We are not initiating post-conviction relief. Post-conviction relief is initiated on the other side of the V. So we did not rush any cases.
If we look at the data in 2024, it won't show that there was some type of increased action on the district attorney's part to move these cases more quickly through the process to get a verdict from a judge and a subsequent outcome.
No, it won't show that there was any action by the defense, by the state. It may show that defense attorneys were anxiously trying to get things filed because they knew something was going to change. But you can look at the records and see who filed what and when, and you won't see any action on the part of the state.
But the district attorney has a part in that process.
Yes, we do.
Whether you take an adversarial position or not, and the judge takes that into account and it determines the outcome.
And we take an adversarial position in the lion's share of these things and have fought a number of these cases. That's not getting
But
publicized.
have you taken a non-adversarial position in an increased amount of cases prior to this becoming effective law during this summer in 2024?
Ask that one.
Have y'all taken a less adversarial position on more cases that were filed by defendants over the summer prior to this bill, this new piece of law coming into effect on August 1st?
No, sir. There was no change in pace.
And I have to, in the fairness, I have to give you the opportunity to speak for yourself. We talked a lot about the definition of public safety. Senator Plessis brought that up as a priority in our Orleans Parish. And there is some differences, and you've explained your explanation as to why there's a difference in statistics and numbers. But what is your definition of increasing public safety, and what do you believe your mission is as a district attorney?
Same mission that you heard from Hill and Moore's assistant. A prosecutor is a minister of justice, and justice has to be applied equally under the law for everyone. Public safety is the primary goal.
Does that include keeping violent criminals who have been prosecuted and have exhausted their pills in jail so they don't re-offend and hurt innocent people in Orleans Parish?
Absolutely.
Is that your number one priority?
Public safety is my number one priority.
But in order to achieve public safety, wouldn't you believe that keeping violent criminals locked up is one of your number one priorities?
Absolutely. However,
if they committed the crime.
Yeah, absolutely. However, I must say that once there's been a showing to a court that a conviction was defective, either because someone cheated or withheld evidence, whether that person is guilty or whether that person is innocent, that is not something that I can, as an officer of the court, sweep under the rug or ignore, nor would any of the 12 judges at Tulane and Broad ignore if they saw a prosecutor withheld evidence in a case of a guilty man. Do you follow what I'm saying there? So it's not just enough.
You have to balance constitutional rights, right. But first of all, if they have committed a violent crime like beating a child, 2-year-old child with a belt to death, raping a female. You mentioned that the domestic violence against females is increasing in the city of Orleans, and you believe in your heart they actually did that crime. Don't you believe it's your task with the duty to keep those people off the street from hurting other individuals? I mean, when they commit that crime, they have torn the fabric of society, and the only thing that stands between them and innocent victims in the future is our district attorney.
Senator Miguez, you're absolutely right. In the case of Mr. Matthews, that matter was, there was a presentation in court, and we fought it. We fought relief in that case. We objected to it. The words and quotes that Laura Canizero Rodriguez showed to you were the defense's words, not the state's words, right? And so when my trials division is saying that the judicial clemency that was granted to Mr. Matthews was illegal, that is right, and that is the same argument we made to Judge Roche. And if in fact he does not grant our motion to reconsider his ruling, we are going to figure out a way to try that case because I believe that he should remain behind.
Let's be clear here, though. But your attorneys waived time limits.
My attorneys allowed the case
so
to be heard by the court.
Your office took inconsistent positions with this case.
No.
Why would you waive the time limits?
We waive the procedural bars so that a judge could have a hearing and the case can be heard. And at that
Why would you do that, though? if you believed he was guilty and should stay in prison,
I see what you're
why would you
I see what you're saying.
waive procedural article?
No, I see what you're saying.
Why would you do that?
I'm going to answer, Mr. Chair.
Okay.
You can't look at the side of a banker's box and figure out everything that has occurred in that case. And if there were violations, and look, and just like Senator Miguel was just asking me, we all believe in the Constitution, but we can't believe in the Constitution a little bit. You can't be a little bit pregnant. You can't cheat some of the time. And so what I'm saying is,
You're diverting
I'm
my
not diverting,
question.
I'm coming right back to it. And what I'm telling you is, the position of the office
And you're
was,
good at it, by the way.
the position of the office was to allow a hearing to be had. At that hearing, we fought it because we thought that the evidence was in our favor and he should not be granted relief.
You could have just ended it by not agreeing to waive the time objections. It could be over.
I could have done that on all these cases.
Right.
Jermaine Hudson still be in
Yeah,
jail.
but why wouldn't you do that?
Because in my first year in office, a man was about to plead guilty to a crime that never occurred. And in the city of New Orleans,
But
we have
it
been
wasn't
so
this guy.
good. We have been so good at mass producing defective convictions that I think it is incumbent that we make sure that we let cases be heard and that the right.
You could have ended this by not signing that waiver, and you did it, and now you're faced with having to retry the guy. But be that as it may, those inconsistencies, and I'm sorry to have interrupted you, but I just want to clarify what we're talking about here.
Senator DePlessis had an earlier question and had mentioned that the voters of Orleans Parish, by overwhelming vote, had voted for a new direction. And it sounded like a philosophical difference that he was describing in Orleans Parish compared to the rest of the state as it relates to your office in criminal prosecution. Can you give us more details on exactly what he was talking about? And I know your office is unique.
Yeah.
Tell me exactly what he meant by that.
Well, I can't tell you exactly what he meant. I know he can take.
Well,
I'll give you my position on
you
it.
were on the ballot, so I mean, I'm gonna let you speak for it. You get the information straight from the.
So
primary source.
I understand why the last presenter will probably spit on my grave whenever that day comes. I get it. Her and her dad and I went back and forth on a lot of different things. Right? That's fine.
Yeah, and those are personal deals, but
Yeah, that's
but just before you can finish that, she did offer a lot of evidence, if true, which could be compelling for this legislature to look further into these matters and to look at potential oversight for district attorneys across this state. Because it's very disturbing that one case when you get a 2-year-old that's beat with a belt, or a woman that's murdered, or someone who kills multiple people. Those are very, very disturbing things. And I don't think that's acceptable in any parish across this state, including Orleans Parish. And if they're true, we have a real problem with that. And I don't want to make it just personal because she's made some allegations. She's backed up with facts. And
She backed it with pleadings.
With
A lot of it
pleadings.
in the words of the pleadings that Mr. Williams' office filed. It should make it up.
And I think you'll have an opportunity to come back before us and hopefully present and whether refute or agree, whatever your position is in each one of these cases. But let's not make it personal so much against her because we're not worried about your personal dispute with her or the former district attorney and you.
I don't have a dispute with her.
We're not worried about who's spitting on whose graves here. We're worried about the public safety for the people of Louisiana and specifically the people of Orleans Parish. And I want to keep the conversation to that point. But if you have a philosophical difference versus other district attorneys across this great state, I want to know about them.
I don't. I just believe that the city of New Orleans has not. When you look at your prosecutors in your home, jurors believe in them. They believe that they care about getting it right. They believe that other DAs for decades have worked to get it right. And the jury believes in the system. In the city of New Orleans, we were sued a few years ago for issuing bogus subpoenas to make people come and testify. Innocent people. I'm not talking about someone who's in the system. Innocent people were forced to come, and we were sued because of that, because people just simply did not believe that the system was fair and equal for everyone. And I'm working really, really hard to build that trust, because we can't do it without witnesses coming to court. And the one thing I'll tell you, I didn't bring that up to make it personal. I brought it up because, there should never be a double standard at all. And in the case of State versus Bobby Jean Johnson, a decision was made to reach a resolution. And my predecessor said, we are satisfied with the result in that we finally got a woman who killed a teenager to acknowledge and accept responsibility for her crime 41 years later. That was the exact same type of resolution that we're talking about today. State versus Michael Thomas, John Thomas, and Stanley Thomas. This is a case in which the DA intervened, the previous DA intervened, and reached a resolution on a post-conviction relief. State versus Michael Williams, Gerald LaBeouf, Louis Alexander. State versus Trinidad East. State versus Albert Wolf. State versus Benedict Cately. These are cases in which the previous DA did the exact same thing that I've done. The only difference is mine was on the record, and we put it in briefs while we made these decisions. In the case of State versus Darnell McNeil, Lon Washington, this is a case in which the previous DA reached a resolution in a case in which Bayou Mama Bears tweeted that we did something wrong when her father did the same thing for a co-defendant.
Let's
4
back
years
up.
ago.
All post-conviction relief has to be on the record, no matter what. It can't be not on the record, right?
We have made more of a record than any past administration of any post-conviction.
Sometimes the defense attorney and your civil rights attorney will go into court, and it's not on the docket, and they announce that they have reached an agreement, and then they hand the order to the judge, and it's done.
Well, I really would like for you to come to Tulane and Broad and see the process, because what's been told to you is
I'm aware.
not how it plays.
I'm aware. Admittedly, I go to the building on Loyola a lot more, but I'll come to yours as well.
I really want you to come.
And you have repeatedly said you're trying to right the wrongs of the past, but not one of these cases that we've reviewed was somebody factually innocent. And that can't be lost on this committee, that these were guilty people, many heinous crimes. And you spoke of domestic violence. These, I just flipping through them, I saw 4 or 5 that were domestic violence to the nth degree. It was domestic murder. And your office agreed to let these people go. And that's why we're concerned about it. And the stated reasons that are in these documents that I've seen are pretty tenuous. But be that as it may, I'm going to let Senator Miguez finish up.
Can I briefly?
Yes, you may.
I do it in 30 seconds.
Of course.
And I believe you're a title attorney by trade, is that
Yep.
right?
Mortgage, real estate, et cetera.
And, whether you buy a house that's worth $100,000 or a house that's worth $7 million, you want clear title. And some of these convictions that have occurred in the city of New Orleans where the person's innocent or guilty as heck don't have clear title.
Well, and if you want to use that analogy, you're not entitled to a perfect title. You're entitled to merchantable title. And you're not entitled to a perfect trial either. And so trials aren't perfect. They're messy. I know that. I'm not a criminal lawyer, but I have tried a criminal case or two in my day. And I've tried some civil cases. And I've tried some jury cases. And they're messy affairs.
Yes, sir.
And they're rarely perfect.
Yes, sir.
But when we have somebody factually guilty, to go in and do this is very concerning. But in any event, I'm sorry, Senator Miguez, I digress on you.
Joy to have you involved in the conversation, Mr. Chairman. District Attorney Williams, in some of your open statements and some of the statements from Senator Duplessis, one would believe, if you haven't never visited Orleans or read the newspaper, that it's a safe place to go and things are great there and crime's going down. You don't acknowledge that there's some serious problems still with crime in the city?
Oh, absolutely. No, look, I don't think the senator was waving a victory flag. I wasn't waving a victory
Just want to
flag.
make sure that's the case. There's still a lot of work to be done there.
A lot of
Would you
work to be
agree?
done, which is why I don't want to derail the relationship that we built on the state level, because we're in 2023, working with Chief Michelle Woodfork, we have brought crime down from where it was before, and we can't ignore that.
And I wanna
But
talk
we
about
also
that
want
relationship a
to, we
little
want
bit
to
as
keep
well.
it going down. We want to keep it going down, and these relationships are important.
To my knowledge, as you correct me if I'm wrong, I don't think there's any other district attorney that has the type of assistance from the Attorney General in prosecuting crimes. I don't think there's any other parish across the state where we have the entire state police going there appropriating money to investigate crimes. That doesn't concern you somewhat that you need assistance from the state to resolve the issues? I mean, that just tells me alone there that there are severe issues, not just small issues. If the state has to appropriate it, look, I'm not saying I don't disagree with what the governor's doing and the Attorney General. There's got to be some severe issues there that need to be acknowledged, and you have to be open to the oversight. If we're spending tens of millions, $100 million there, and we have to send state police, our own police force, and we got to get the Attorney General to prosecute the crimes. I mean, at this point, will you turn this Orleans Parish around and all your locals, or should the state just run the parish for you? Do you think we'll get it back?
Well, Senator Miguez, I'm here voluntarily.
Yeah.
I came because I wanted to have this conversation, just like Senator Cloud was saying. I'm not going to claim that Orleans Parish is perfect. We got warts and moles out the wazoo. But I'm also not going to ignore the successes and gains that my office achieved at the worst possible time. At the worst possible time. And I'm also not going to pretend that the city of New Orleans is not sending a great amount of revenue to the state.
Absolutely.
And the fact that the governor and the AG believe that helping a parish in the middle of a crisis help it achieve more public safety gains, I think that's a good thing, because another parish is going to be in the exact same boat, because that's just the way the world works.
But the fact remains that constituents in my district, and as well as many of the people on this panel, don't feel safe going to Orleans unless they got a large caliber pistol, 2 spare magazines, and wearing a bulletproof vest. And we got to get the situation fixed.
Well, I can tell you there's not a single prosecutor in this country who's tried as many murder cases personally in court and gotten convictions in this country. I am in court with my young prosecutors, teaching them how to try the toughest cases, teaching them to try rape cases, serial rape cases, and I'm going to keep doing it. But we're working really hard to fix our own problems. We appreciate any other assistance that comes to bear. But a big part of being able to prove a case in court is having a jury pool and 12 members of that jury believe in the office. And we have been building that trust. And part of building that trust is what we have done in the Civil Rights Division. And the chairman's right. It's messy. There are some gray areas. But I would invite all of you to come and watch the process to understand that we're just trying to make a fair system, to make sure that everybody, because in Orleans Parish, you might have one family that has a victim in January and a defendant in August. This is very tight quarters. It is very close quarters, and people need to believe that the system is going to treat everybody fairly when they come through it. And just looking back in cases when there is defective title, I'm not saying perfect title, but defective title, making sure that a court of law and the DA will not ignore it, regardless of guilt or innocence, but let the court make a decision. I think it's the right thing to do. But look, I am open and willing to work with this body and any other body to discuss making sure.
And we appreciate that.
Yes, sir.
As this process plays out and we get to the bottom of the facts and we have further hearings, do you think other district attorneys across this state will sit next to you and approve of the decisions that you have made in the past on subsequent post-conviction relief? Do you think they support you, your colleagues, and your peer group?
I think that.
Or will you be standing alone defending yourself?
Like I said before, when you asked me what Senator Duplessis was thinking, I can't tell you what another man is thinking or another woman is thinking. What I can tell you is that the district attorneys in this state have discretion to deliver on their commitments and the mission, and it's the same mission, and public safety is the ultimate goal. And that discretion is very important, because each judicial district is very different. Each judicial district has very different needs. Each judicial district has a very different history with the criminal justice system.
And but you do also recognize that the decisions that you're making and the actions in Orleans Parish is bringing them under a microscope as well, and the legislature considering things that haven't been discussed in great detail in the past about potential oversight over district attorneys in this
That
state.
keeps me up at night.
Very similar
That
to
keeps me up at night.
and it happens in other states across this nation.
I've watched what's happened in other states across this country, and I
Because
would
of-
hate for people to come to New Orleans for the Super Bowl and see the city of New Orleans and the state of Louisiana
and I bring
waging
that-
some kind of war
It's not a war.
over discretion. I would hate to see that.
I use your own words of trust. Not only do you have to earn the trust of the people of Orleans Parish, but you have to earn the trust of the other constituents across the other parishes across this great state, because Orleans is such an asset to the state, and we want to make sure it's successful. But remember, the actions of your office and all the people underneath you affect the rest of the district attorneys in this room, who this legislature supports. We want to make sure they do a great job, but we'll have more hearings and we'll get more details. And I just want to make sure on the record, whatever the chairman submitted to you in that letter, I don't know the exact details, but I want to make sure that you can come forth in the future and address each specific case that Ms. Rodriguez had brought forward, or any other cases that she provides to this committee as well. Because we want to hear about the specifics, to let some of the attorneys get involved in that and get a specific explanation, because there's some very appalling accusations or cases that were brought forward today.
Yeah, and you made and I appreciate you keeping that phrase in there. What Ms. Canizero Rodriguez said, if true, I remember you said that. And I look forward to you all being able to look at the complete record and make your own decision.
Thank you so much for your testimony here today.
Thank you. Before I get to Senator Duplessis, I got a couple of things I want to go over. First of all, in response to Senator Miguez's question, do you have a different philosophy from the other DAs? And you said no, or absolutely not. I can't remember exactly. I would challenge you on that, because you ran for office on a progressive platform. Did you not?
Look, I said that the criminal legal system needs to be as smart on crime as it is tough on crime.
Right. So you ran on a philosophy that's different from a lot of other DAs. You said that you wouldn't enforce, for example, if there was a abortion law crime.
Is that why we're here?
And you said you wouldn't. No, but you said you didn't differ philosophically, and I'm saying that I'm challenging you on that, and that's just an example. You ran on a philosophy that's quite different from the majority of the DAs in the state, right or wrong. So I think that can't go unnoticed, because as you'll notice from the legislature, we have probably what would not be considered a progressive philosophy as a whole. So, everybody's different. Senator Duplessis and I don't always agree. Every now and then we do. So I think that's something that we're going to be thinking about. Now, another thing I wanted to ask you about is I asked about your internal policies that you have with respect to post-conviction relief matters. Do you also have policies in your office regarding conflicts of interest? Because a lot of your assistant DAs and you as well were formerly defense lawyers, and of the 36 to 40 cases that we reviewed, you and some of your assistants were defense lawyers on some of those cases. So do you have a policy, written policy, in your office to address that?
Yes, sir. And if there's an instance in which there is a conflict of interest as defined by law, we have referred that case to the Attorney General. In fact, there's an email, Tim, we can share it with this group. There was one case in particular that I think was brought up, the case of Jared Crowther. It's a case in Section J. Can you hand that to pass that to the committee? It's a case in Section J involving an individual that was previously represented by someone who was an associate in my office. The judge in Section J recused the DA's office because that lawyer had previously been working in my office. In court, the judge said that he was going to appoint the Attorney General. The judge didn't do it. The judge did not appoint the Attorney General, and at a later date appointed the Loyola Law Clinic. This email is an email that my office sent to the Attorney General's office, making them aware of what occurred in that
Now,
particular
in
case.
some instances, when there's appears to be a conflict, you obtain the appointment of a quote-unquote special prosecutor, as I recall, from some of these cases. Have you ever done that? Was a Ron Wilson ever appointed as a special prosecutor in any of these cases?
What case are you referring to? I just don't have that in front of me.
Let's see if I've got it here.
I don't believe that I've ever appointed a special
You've never gotten
prosecutor
a
or
special prosecutor appointed?
The only case that I'm aware of that is currently being dealt with right now under my
Well,
administration
look.
would be that case in section.
I don't have it in front of me, but that'll probably be the subject of a subsequent hearing. But regardless, you do have written internal policies, and of course, we requested it in our letter, so we hope to see that in 45 days, which I would say, let's make it October 15th, just kind of right in the middle of the month, which.
Yes, and I think it's under the law, if I could just make clear, I mean, DAs and prosecutors, we don't appoint. That's not how that
Yeah,
works.
well.
That would have been the court.
Yeah, it would have been the court. Okay, fair enough. Okay, on to Senator Duplessis. Hang on, Senator Miguez has a point of order. Let's see what.
Just real quick, Mr. Chairman, I was reading through your letter about the requested information. If you happen to decide to have a subsequent hearing, could we get the, whoever's in charge of the Civil Rights Division here with the district attorney next time?
We can request, and if, need be, we could,
Subpoena.
subpoena.
We're going to get him here. Okay, I appreciate it. I think that would be very helpful.
I did request Ms. Mall's attendance today, and I didn't hear back from her, but be that as it may, I wasn't going to push the issue
And let me
just
just make
yet.
it clear, I thought it best and prudent. As I said before, everything stops with me. The
Right.
buck stops with me. I am responsible for what happens in the Orleans Parish District Attorney's Office. And so
Yes.
the idea,
Mr. Williams, but if we have a subsequent hearing, we're going to probably be digging down a little bit deeper into the details, and I think it would be beneficial that both of y'all were here to help us provide the adequate information, if that's okay with you.
like I said, I'm here voluntarily. I mean, I've got,
Does that
I've got
mean
tri- I've
that
got
we-
cases I've got to
well,
try.
She works for you, so does that mean we can get her to testify?
I just want to make it
before
clear
this?
the buck stops with me. I am responsible for what happens in this office.
Yes.
I think he's looking for a yes or
Yes.
no.
I know that.
So the question is, will you ask her to come voluntarily, or do we need to subpoena her?
I mean, it all depends on when we do it. If we're going to doing this every week, then, I got cases I got
the
to
chairman's
try.
gotta handle that.
There's no definitive plan, but what we need first is all the documents.
Yes.
That, getting them from the clerk of court was very difficult, and your office provided some to
I don't
Ms.
control the
Merle,
clerk of
and
court.
that was, I understand. And the documents provided to Ms. Merle were very helpful. So once we get those, we're going to review those, and we have some prosecutors and people who are going to help with that.
Yeah, and I'm sure the chairman's going to work on scheduling, but
And so it'll be we'll have to get the documents, then we'll have to analyze them, then we'll have to have another hearing. So I don't anticipate one anytime soon. So no, we won't be here on a weekly basis.
he did that, Mr. Chairman, he did that sidestep thing again. He didn't tell me whether she was going to show up at this committee.
We don't have a date yet.
Once we have a date, maybe we'll get an answer to
What y'all
that
want to
question.
do? I mean, I'm glad we're talking about this. Let's keep talking about it.
Do you have any reservations with her speaking in front of the legislature?
No, I mean, I had reservations about coming because I didn't quite know how I was going to go. I mean, you didn't. I don't spend a lot of time at the Capitol. I spend a lot of time in court.
I understand that.
I'm on different ground right now.
Okay, I think you understand where we're
But I'm
going.
more than willing to provide all of our documents. and
And
provide
people.
all of our information.
And employees.
And I'm here voluntarily because
And
I'm glad
employees.
we're talking about this.
And
Well,
employees.
I don't think we're going to get an answer on that,
Well, let's,
Senator Miguez.
I'll
but
start researching the subpoena process if it's
at some
necessary,
point-
if I can't get a straight
At
answer.
some point, we'll have to cross that bridge, and hopefully we won't have to fight our way across it, but we'll see. Now on to Senator Duplessis.
Thank you, Mr. Chairman. And DA Williams, I just want to thank you and your staff for being here. This is a lot of time and resources being dedicated to an hours-long hearing when we have big issues in the city of New Orleans that we need to be tackling. So I just want to thank you for your willingness to come here today, your cooperation, and your service in a very difficult role, which is trying to stop crime in the city of New Orleans, to try to make New Orleans a safer place. We can dispute whether or not we should be celebrating the significant reductions in crime, or whether we should be focusing on the lack thereof. The more that we have to do, we can go back and forth on that. But the fact of the matter is, violent crime in particular, has been significantly reduced. And I think for a lot of different reasons. And I would like to take this opportunity for you to talk a little bit about some of the other programs that I know that your office has instituted outside of just post-conviction decisions, like the No Dice program and other things that this office is doing, because this hearing has seemed to morph into something other than a conversation around post-conviction. And I think I see where it's going, but I'd like to just give you that opportunity to talk briefly about some of the other work that your office is doing, in addition to what I think is an unprecedented move to voluntarily work with the AG's office, to voluntarily work with state police, to voluntarily work with the governor's office to welcome support to the city of New Orleans to deal with the issue. So can you talk a little bit about some of the other work that your office is doing?
Absolutely. So it's absolutely the hardest job I've ever had in my life. And I want to say that you talk about these other DAs around the state. These guys these women and men work very, very hard to try to make their jurisdiction safe. And it is a difficult task. And in the city of New Orleans, we have more incidences of crime. And in response to that, we have partnered with a group called Bancroft Global that includes former FBI agents, CIA agents, and NSA agents, using the same techniques they used to go after Osama bin Laden, figure out where he was. We have brought them in to help us use social media to solve crime, so that we're not just arresting the shooter, but we can actually get to the driver and any accomplice and anybody else that was involved in those cases. And that work is yielding very solid results in court. It's gaining national attention. We brought in Chief Michelle Woodfork, who is learning this work from these NSA and FBI guys, and the relationship between myself and the NOPD homicide detectives has never been better. It's bringing crime down because we're actually solving it faster, and so we've got a faster solve rate. On the flip side of that, I've got Daniel Shanks and Andre Godin, who have helped stood up the No Dice program, which is working in collaboration with every department at City Hall, the City Council, and we've shut down problematic corner stores that were selling drugs and guns right outside of the French Quarter. One police officer stopped by and said he'd been complaining about that building since 1981 when he was on the force. He's retired now. We shut down the tire shop on Claiborne Corridor, where there have been murders and rapes and drug dealings. And Councilmember Eugene Green said that the Baptist minister around the corner had started back having Bible study after we were able to shut that place down. And we were able to have the city come in and put up street lights in that area as well to make it safer for those children who have to cross that intersection to get to school. The No Dice program just yesterday announced the closure of the London Lodge Motel, where a 3-year-old had been shot through a wall, where a rape had occurred, where a murder had occurred. And that is working in communities, figuring out those places that are the hubs of violent crime so that we can root that out. And that has been a game changer. And so, yeah, we're working really hard with the Civil Rights Division to deal with defective convictions in situations where things weren't done right before. Sometimes it affects an innocent person, sometimes it affects a guilty person. And it is deeply painful and traumatic to go through. And we have reached out to victims every step of the way to let them know what's going on. And in one instance, in the Darnell McNeil case, the family wasn't aware that the last administration had reached a resolution. They were only aware because we had reached out to them to talk about this last case.
But in some instances, the victims complained and didn't want somebody released, and you agreed to release them anyway.
And we represented the victim's words on the court and read the
Right.
victim impact.
Otherwise, we wouldn't know that.
No, my office.
I understand, but we, as a committee, would not know that if it wasn't on the record.
Oh, but I would have shared that with you.
Right.
I'm not going to
Right.
hide anything. I'm
I
not going to hide anything
understand.
because I want
I
you to be able to
understand. I
see
understand.
which ones we fought, which ones resolutions had to be made on.
I understand.
But to answer your specifically, we are engaging in partnerships that you've never seen before. And the work with the governor and the AG on electronic monitoring,
Right.
which has been a problem from everywhere from West Feliciana and to Orleans Parish. The AG and the governor brought in the Supreme Court. They brought in senators and representatives and OJJ to help us deal with the problem of electronic monitors in the parish of Orleans. And I truly believe we're going to come out of it with a better system of accountability for young people. And, you know, that type of collaboration, I don't think existed.
I agree. When Act 10 was introduced and passed during the special crime session, did your office take any public opposition to that? Did you oppose that law in any way?
We did not.
Okay.
We will follow whatever the law is.
Right.
If the law changes, we'll follow that law. That is not the role of a prosecutor to create new law. And I agree with AG when she said that. It's not my job to disagree and do something else.
Right. So you
Now, there
work
may
with-
be disagreements about the process and the resolution, but following the law, we did it.
Right.
Abiding by the law, we will continue to do it.
And just my final question, kind of goes back to the question of philosophy, and that's been brought up a couple of different times, the creation of the Civil Rights Office itself, and your belief that there was a need to do that. I think a lot of times, particularly in this building, because Chairman Morris represented that this is an overwhelmingly conservative legislature, right? And we're talking about it in the context of public safety, as though the people from New Orleans don't care about public safety. What I want you to do is just speak a little bit about why justice, from the standpoint of the Civil Rights Division that you created, is so important for the sake of trying to achieve public safety, because those two things are not, they're not two separate ideas. How do we use the resources and the effort you've put into trying to correct injustice for the purpose of making New Orleans a safer place?
So as part of our effort to win cases in court, part of that effort required building trust that did not exist. And in an effort to build trust in the criminal system, we have used our discretion, always within the guardrails of the law, to allow courts to look at the fairness and constitutionality of past convictions and sentences. And we've done this hand in hand with fighting for convictions in violent cases, including cases where the courts have sent them back. My job is to make sure that justice is served, and I think it's clear that some of your maybe more conservative colleagues believe that I have leaned too heavily on correcting the wrongs of the past. My office has been measured, it's been transparent, and I've listened to the community, and I've relied on data to inform our policies. My policies haven't been dogmatic. When faced with a global pandemic and a nationwide spike in violent crime, we reconsidered our position on the multiple bill, and we have been applying it on violent offenders. When faced with juveniles planning and carrying out violent crimes, we've reconsidered the juvenile transfer law, listening to community to deliver. But at the end of the day, it does not work if people don't trust the system. It does not work if communities don't trust the prosecutor. We've gotten to a place now in the city of New Orleans where people do trust the system. They do trust the prosecutor, and they're coming to court and they're playing their role in public safety, being the change they seek, testifying in court against the bad guys because they know we want to get it right. And when we find the right person, we're going to make sure they have a fair trial.
Thank you, Mr. DA. And I know we've already passed the 1 o'clock hour. I want to thank you again for being here today voluntarily. I want to thank Chairman for allowing me to be a part of this conversation. My hope is that as this goes forward and that this legislature continues to do its work, that we keep in mind the fact that this is valuable time and resources that we're pulling away from the district attorney's office being able to actually do the job that they were elected to do. And that's important. Let's not lose sight of that. Because every second, every minute, every hour that we're dedicated, that we're focused on what I believe is in a lot of ways misguided attempt to push an agenda, we're getting away from the opportunity
Or to make campaign speeches, too.
To make our community safer. To make our community safer. Thank you.
Thank you, Senator Duplessis. I thought we were close, but Senator Abraham.
Yeah, I'm going to kind of maybe wrap it up. First of all, just state from me, and I believe I speak for the committee, there's no political agenda here at all, okay? I want to just state that very clearly. Second, evidently you are doing a lot of good programs that Senator Duplessis asked you about, and evidently they are good, okay? But you know, I have a saying that the good is the enemy of the best, right? The good is the enemy of the best. So what does that mean? For all the good things, we want to be the best. So when we see from these last 3.5 hours, when we see all these cases in the last 6 months that I believe are abnormal, from just a number standpoint,